Slough.
Okay, Slough. Terrific. Who's making his note-taking debut, and we welcome you. Junction Arts and Media is here enabling our digital communications and recording. Thank you for attending this special meeting of the Select Board, which has general supervision of the town of Norwich. We appreciate our contributions of our town employees, elected and appointed officials, and the many volunteers that make our town what it is. We endeavor to be respectful of everyone while keeping what is best for Norwich as our North Star. If you are recognized during the meeting to speak, to a maximum of 3 minutes, Vice Chair Klassen has been invited to remind you when your allotted time is up. Thank you. Number 1, agenda. Discussion and motion. Would anyone like to move the agenda?
Like some clarity on something. So we've been discussing an executive session where we had a straw poll, but that's not under consideration tonight, right? That's to be resolved at some other time, or is that part of this?
That is not part of
Good,
this.
I just wanted to be perfectly clear that we're talking about events that occurred in a certain time frame, and that's what we're doing tonight. That's fine, I'm just saying I wanted to be clear on that. There's no need to be suspicious of it.
No.
This has gotten so complicated that I kind of lose the plot sometimes, you know?
Yeah, I do.
Right,
Me too.
Indeed, it has.
right.
Thank you, Mary.
I think our hope is for a general discussion about many things that all relate to one another and find a solution.
But not that.
I haven't specifically said that or,
Okay,
I mean, that's not on the agenda if that's what you're
yeah, that's what I
specifics.
was wondering about. Okay,
Good question. Where to be? Anyone like to move the,
I move to approve the agenda as presented.
I'm happy to second that.
Oh, classy.
Rob, you can.
all right, any discussion? Let's vote. Klassen,
Aye.
Layton,
yes,
Gear,
Yes.
Sweat,
Yes.
and Griggs is a yes. Terrific. Agenda is approved. Public comments for items not on the agenda. Are there any members of the public who would like to? Oh, there's a hand up. Chris Clement.
Hi, Chemo.
Hi.
Chris Clement, Norwich. I just wanted to ask if there's any chance you can get the transfer station issue on the agenda next week and get an update if anything has been done. I don't expect you to talk about it today. It's not on the agenda, so I just wanted to encourage you guys, if you have space on the agenda next week, to have time to discuss that.
Okay. Generally, we put things on the agenda when we have something in the packet to support it, so everybody can read what the issues are. It's hard for it to discuss things when it's just out in the open air. So I would invite you to put something in the packet.
I already wrote you guys.
letter.
Yeah.
Oh, there is something.
There was a letter that she sent in.
Yeah.
Okay, so let me see if we can respond to that.
Great. All right, thanks.
Thank you. Yep. How did you know it was in the packet? Just curious.
She sent it to us and the packet.
Okay. Okay, great.
Thanks, Matt.
Any other items from the public? Seeing none, I think we move on to number 3. Proposed responses to Katucki notification of OML violation filed with the town of Norwich 6th of April 2026 and PRA suit 26-CV-02624 filed with Windsor Superior Court on the 4th of May 2026. I've got 4 pieces here. First is preliminary public discussion. If anybody has questions they would like to ask, followed by a proposed executive session, Following that, a public statement, followed by public discussion and possible motion. Are there any questions regarding the proposed responses? Public or within the,
Mr. Chair,
yes,
if there are no public responses, if I may go.
you may.
Okay. So I think it's really great that we have this before us tonight. And I think it's fair to say we've debated this matter and our response to this matter back and forth for, I think it's next week is almost the 6-month anniversary of the first dated email that plaintiff Mr. Katucki has requested a line of sight on. So this has been a matter that's been very much in the select board's purview for some time. It's actually gone on so long, it's transcended 2 select boards. So it's been a long time. And I think if we distill it down, and it's certainly, I don't think we could be criticized of acting rashly, acting in an uninformed manner, because I think we've had time to digest this, and I think that's been great. There's a lot of diverse opinions, and I think it's been very important that we take the time to collate and digest and accept and understand all the opinions, which I think has been great. There's been a lot of executive sessions, a lot of public sessions, and it's been a little bit of a hoary chestnut, but I think I just wanted to say that I feel this matter essentially reduces to the simple question that really can be stated simply, that do we honour the right of a citizen, resident and taxpayer of our town to satisfy a reasonable and lawful request for public documents? Or do we, by some means or another, deny that right? If we put aside the issue of costs for the moment, and the issue of costs are, I think, shall we say, modest. They're around the $500 mark. I think it's really important we ask ourselves, what is our obligation here? As representatives of the citizens of the town, representatives of the public servants, what must we do to meet our obligation to the public? I yield my time.
Mary.
I've been wondering in both cases, both the agenda formation piece and the Public Records Act piece, whether decisions would have been able to be made in a more clear way if we had some policies in place. Like, for instance, of who should see the draft audit. Is there a procedure? Is there a policy? Especially in subsequent conversation that maybe the Finance Committee would like to see that. Where's our policy there? And then also with the Public Records Act request, with whatever decision is made by the court in regard to Mr. Katucki's concerns about his access to public records, will those decisions affect policy that we have not even adopted yet? Like, we don't even have a basic Public Records Act policy. I think we have procedures, but I'm just wondering how that will affect any future policy decisions that we might want to make if the court decides one way or the other. Are we forced in a certain direction? And also, if any citizen would like to see records, there is some provision that, you know, they should pay for the copies and pay for the time. I'm actually more concerned about time that we could have citizens, just show up and tie up our town employees' time when they could be working more productively. And I think part of the reason to have good policy is to sort of cut down on that happening in the first place. But I don't think that I'm comfortable, even in the case where someone needs accommodations, to have it be completely free, almost even if it's $1. I'm just uncomfortable with it.
Yeah,
So,
it's a funny thing because it's so little money for so much work, no
well,
matter how you slice it.
I have one more thing to say. It's just that I respect Mr. Katucki's expertise. His perspective, I think, might be a little more strict than what I'm comfortable with, both in regard to agenda setting and his Public Records Act request. It's like, I don't really totally agree with that. But I will say that when he takes an action, since he's already a lawyer, he doesn't sort of pile up a lot of cost except for his own time. Whereas the town has to meet every single action that he takes with expensive time that we have to buy. So it seems to me, even in the initial lawsuit, which was about the working groups and so forth, which we lost, and we, spent a lot of money for that, it was very asymmetric. There were many pieces of information that appeared to not directly apply to what was trying to be resolved, but were there to kind of create drag. They're kind of to create tying up lawyers with time to say, well, this assertion is, sort of not relevant. So that's a part of Chris Katucki's actions I really appreciate, like bugging us about the opioid fund. I really appreciate that. But, it's just in the actual engagement between us and Chris Katucki, it's very asymmetrical. And I feel almost a little bullied by it. It's serious. And I don't know if it's right to always cave into it completely. I think we should try to think about this in terms of future policy, in terms of what's going to work for any person who needs accommodation, whether it's Chris Katucki or some other person. But if we could keep those kind of factors in mind as we decide this, I'd be more comfortable with this whole thing. And also, as I was mentioning in the beginning to Brendan, I kind of lose the plot on this because a lot of it's procedural, a lot of it's, well, where are you in taking a step to do something? Have you followed, even the new and strict policy that we've already put in place? Or do you have the sort of the intuition to say, straw poll, that sounds like an action. Is that ingrained yet? Maybe not. So there's a lot of this that I think has to become, there's sort of the overall framework, but part of it also has to become a habit. Has to be like maybe you're on your guard, we're on our guard for actions in executive session that might be construed as an action or are an action and not get tricky about it. So that's my perspective right now. I don't know. I'm hoping that we can put this to bed in a way that makes sense, doesn't drag on. I feel like we've wasted a lot of our time when we could be actually adopting a PRA policy or doing more policy work, doing other things to help the town. So that's my little speech for tonight.
I think I completely agree with your sentiments.
Thank you.
Well, I mean, Matt, did you have something you wanted to?
I also understand what you're saying. I would much rather be focused on things that I see jumping us forward in increments in improvement for the town stuff that we have. I think we all have our short lists of that, and this is not on that. But as we've been, I had the benefit being away for the past 2 weeks on vacation. I didn't actually vacation my brain, and I kept thinking about this stuff and revisited a lot of the things. And I do feel like if we were to look at another angle or a positive part of this is that we have, by going through this sort of rigorous chore, we and future select boards will likely do our executive sessions with much more clarity and intention and transparency. Even if we go into executive session, we'll do it with more reasoning and explanation to the public why we're doing this thing. And then we are better learning how to come out of executive session and be more detailed about what went on, what we learned, and then as we come out into public session, the actions that we would like to take in public. And so while I totally understand what you're saying, I also think that this might, in the end, kind of improve our dialogue with the entire town about what's going on and allow the public to more to understand fully kind of a topic, even if it goes into executive session, and therefore be able to give better input. And I've struggled with the more transparency we have and the more that we tell the public about what goes on, even in executive session, the less misunderstanding and inaccurate assumptions will come out of that. And so I hope for that too. But, sorry.
Well said.
Thank you, Matt.
Rob, any?
Yeah, I appreciate Mr. Carroll's comments over the past few meetings that attempted to set straight the importance of open meeting law and the guiding principle of transparency in government. What I run into, in addition to being aware of that and having some opinions changed as a result of that, but I also feel strongly that the process has to be compliant with the law. And that there are areas that in this instance, in some of what we've been struggling with, where claims are put forward and then brought to court, that procedure was not correctly followed when those involved came up with the impression that they were. So there's a difference of opinion, and a difference of opinion in areas that can't be discussed until they're resolved, which is a difficult thing to deal with. So, like this meeting with these motions are very clear what they're about, although they're referencing actions that aren't necessarily fully expounded upon by talking about the case and the statute and so on. But it's definitely a movement that we've made as a result of these issues. And that's to the benefit of the public and to the benefit of the board.
Okay. Good thoughts. We have a member of the public.
If you're ready.
We're ready. Born ready.
Bill Lindbergh, resident. I've sat through many a select board meeting. The open meeting law became a very important law for transparency to the public. When we had the first lawsuit, both Bob and Mary were a part of the select board at that time, and people in the town were begging them to stop the lawsuit and resolve it. Then the settlement came, and it was to do things better. We had made a mockery in Norwich of the open meeting law, and I'm pretty sure the two of you can remember that being stated.
The court.
Yeah, we had made a mockery. Seemed to me that anybody that had been told that would do everything to avoid another violation of the open meeting law. And there, as an elected official, I'm subject to the open meeting law. And occasionally we forget to put the draft minutes out in 5 days. But what has happened here at this table with seasoned select board members is you've allowed executive sessions that have no basis. You made them up. You got pulled in by erroneous requests. And they should have never happened to this select board. And it's very concerning to me as a resident to see this happening again and again. You're adults, you're smart, you chose to serve, you got to do it right. And you got to get past this and do it right going forward. It's a simple process to follow. Do you have the authority to go into executive session? And here are the reasons you do. And that whole draft audit piece is junk, for a kind word. And that isn't finished yet. But I'm telling you that I saw this coming, and I said to people, do not go into executive session. You have no basis to do that. And you did it anyway.
Thank you, Cheryl. Mr. Chair?
Yes.
Oh, Pam Smith first.
Pam Smith, would you like to speak?
Yes, thank you. I've resisted saying anything all of these weeks and months, and I gotta say that you really need to think about the nexus of why you are where you are right now. And it all boils down to an unfounded accusation that was made back on January 21st or 22nd. And the board at that time bought into that unfounded accusation and ran with it and had a, what was it called, chain quorum meeting. And then they went into executive session, and it has just snowballed. And I agree with Cheryl. It's time to stop. And Mary, if you want policy, how about a policy that the board investigates unfounded accusations to get to the bottom of them before you go into executive session or before you buy into somebody's supposition? So that would be my suggestion. Don't buy into something that somebody thinks might have happened. Do your research, talk to people, see if it really happened. And if it happened, fine, take action. But I can tell you that this was an unfounded accusation, and this board has gotten itself all tied up in knots over following something that never happened. and making the assumption that it did. So that I had to get it off my chest. That's how I feel. You need to stop this nonsense. Thank you.
Thank you, Pam. Rob, Chris, we'll get to you in a minute.
It's one of the primary reasons that boards have on occasion gone into executive session is to discuss charges like that out of the public's eye, to try and determine if there's any validity to the argument without allowing someone's reputation to be besmirched unnecessarily. A simple statement of why somebody would want to do that out of the public eye. And it would be difficult for the board to investigate charges like that without some sort of a meeting. And if it's publicly stated, then why bother is perhaps the way to look at it. If you're going to try and protect somebody's reputation from being unjustly accused, that sometimes requires looking at the charges out of the public eye.
Mr. Chair, may I respond?
You may.
Thank you. Rob, that is
Pam
not
Smith.
what Pam Smith, resident and one of the accused. I disagree with you, Rob, that what has happened has actually done more damage to the reputation of the two people who were accused. And when this first happened, Cheryl was asked if she had shared that draft audit with me, and her response was no, but apparently that wasn't a good enough answer. So no one came to me and asked me if it was shared with me. So if you want both sides of the story, you should talk to everyone involved. And I was never asked. She never shared the draft audit with me. And here you are, like I said, tied up in knots over something that never happened because you didn't do your research correctly in the very beginning. So if you want to, you don't need an executive session. You didn't invite me in. You didn't invite Cheryl in, but you went into an executive session to talk to the accuser, not the accused. Thank you, Mr. Chair.
Thank you for your comments. Mary.
To respond to both Cheryl and Pam, since I'm kind of, at the center of this. So what do we do with a question that is not answerable without some investigation? So should that investigation have been my duty as chair just to ask around, or how would that be, how could that have been more gracefully resolved without it turning into this huge mess? Because my reasoning was more along the lines of Rob. It's like, it seemed like there was some sharing, was not aware of a policy, but there seemed to be a procedure where, the draft is sort of kept under wraps for a while, and then it's brought out as a final draft for everyone to see. So it seemed like there was something going on there, but what would have been a more graceful way to do that where, reputations are not damaged and we could actually sort of know what's going on with an important process for the town.
Mr. Chair. Mary, that's food for thought, and I appreciate you offering that. I think it dovetails into a question you asked this forum, perhaps rhetorically, some months ago. How do we exercise good judgment? I remember you posing that question in a rhetorical sense.
I think I did tonight too.
Which I have to tell you, I've been thinking about again and again and again since you said it. So it's a great question to prick our consciences, interrogate our behaviour, examine our comportment as elected public officials. And it's been a challenge to sort all through this, but in many respects, we enjoy the separation of powers federally and state. There's an echo. But to some extent, the three powers converge on the select board: executive, judicial, legislative. Our powers are not universal, they're not overreaching.
Excuse me for a minute. Point of order. Could someone
Yeah.
mute whatever that sound is?
Chris, your mic is open. Thanks, Chris.
Thanks, Chris.
Yeah,
So
sorry, continue.
to the extent that the three branches of power converge on the select board, it's an onerous responsibility to recognise our limits. And one limit that really became clear to me, and I sent this to you in the memo, that restricted within the select board, it's not in the public domain, so I can't speak too much about this, but our judicial authority as a select board is very clearly circumscribed by statute. We can adjudicate on matters such as maybe property tax disputes and agreements that involve valuation of properties and generation of revenue for the town, these types of things. What we categorically have no influence over, none in statute, absolutely none, is the ability to interrogate and adjudicate and threaten with dismissal or disciplinary action another elected official of this town.
So you're taking issue with the reason to go into executive session, because that was how it was framed.
I'm taking issue with the assumed overreach of this body in electing to challenge, interrogate, and question the actions of an elected official in this town.
I must respond to that, actually. So
It's beyond our remit.
no, I think there is a matter of balancing, because we do have to work with the other officials in the town to get good results. And the production of the audit is an example of that. Okay?
But as with us, they answer to the electorate.
Yeah,
We
this
do not
is,
answer to each other.
okay, this
I know,
is getting
Mr. Chair.
outside what's been warned here. This is more about select board responsibilities.
Well,
It is about, it may have been the cause of a Katucki action, but it's not what we're talking about. We're talking about Katucki's response to things we did, not what we,
well, you had framed this as a broad discussion, but I'm happy to move on.
yeah. Well, no, I'm just trying to obey what I believe the law is, that we can talk what's warned, but if it goes wider than that, I have to rein it in. So it's related, but not of the argument. Yes, we have a key.
Thank you, members of the Select Board. I'm John Carroll. A couple of thoughts. One is that, yeah, this has become a rather wide-ranging conversation, reaching all the way back to the week in January and so forth. And they're all connected, of course, but your agenda is a discussion preparatory to taking some kind of action in connection with the lawsuit and the notice of violations. I guess I would just, listening to the board members who've been here a long time, I heard you use the term bully, and I understand that feeling. And I also heard speaking about how the plaintiff, in the case of the highways, the meetings, and also in the present case, is sort of bullying and has resources. But the irony, of course, is that the town's resources are vastly greater than his. The town spent $100,000 thereabouts defending against the complaint that Mr. Katucki launched 3 years ago. so you weren't short of resources. You had very, very adequate resources, dozens of hours of attorney time. You haven't been short of resources in the instance of the town manager soliciting the advice of Mr. Smith to review documents. I can understand why you'd be concerned about fees, because you have, the town manager spent a good deal of money, not only his time and that of his staff, but also bringing in an attorney to pursue an approach, what you could say. I guess I would want to just, I'm somehow reminded of sixth grade. Okay, and just stay with me on this. It sounds crazy. I remember first grade, second grade, third grade, we had very, very easygoing teachers. And we kids just sort of did stuff, and we got up and we moved around and we did stuff. And when we got to the sixth grade and we got Mrs. Swisher, and Mrs. Swisher was like a German military officer. Sit up, be quiet. I don't mean any dispersions. I admire the discipline. We were required 7 hours a day to sit up and pay attention. In those days, you could slap hands with rulers, and she did. And all of us boys, especially with being boys, we grumbled about this. And we thought, God, this is such bullying. This is so much, blah, blah, blah. And at the end of sixth or seventh grade, we were much better off. We knew how to pay attention. We followed the rules. Yeah, we followed rules. And our parents, of course, were very happy about this because finally we were being asked to kind of live within the boundary lines of civilization. I don't know much about this, but my sense from watching at kind of a distance is that in past years, the board has gotten in the habit of conducting itself in ways, some of which, for example, you recently acknowledged we shouldn't have been doing that. The way you go into executive session, you agree, gee, we shouldn't have been doing that. But you've been doing it that way for probably 5 years anyway. So I can see for how it is for some of you, like, God, you're changing all the rules on us, or we're changing all of our understandings about how this is supposed to be done. And I guess the answer to that question is yes. And I can see that it is awkward. I respect each of you as people and as citizens, and I can see how in this service, you're being asked to throw away some conventions that you had been led to believe and had accepted were okay. And truthfully, they weren't. The most recent notice of violations allowed you, kind of brought you right up against some specifics and how they relate to the law. And you could see, all of you could see that you'd been drifting off the path. And so much of this is about kind of helping you come back to the rules of the road, kind of that going forward. And And just to leap ahead to the next topic, which is to go into an executive session, I want to just, it'll save me jumping up and bugging you about it. I want you to remember that you must make a specific finding, and that premature public knowledge would clearly place the public body or a person involved at a substantial disadvantage. You must make that finding. You can't just say that is so. You must present information to the public which gives evidence that, gosh, if we were to say all this in public, there would be a substantial disadvantage to a person or the public. You must give that information. I know you know that. That's one of the things that we all learned together when we dealt with the notice of violations. I'm just reminding you, you can't go back to the old ways while you go into executive session. You can go into executive session, just got to do it right by the book. Okay, thanks.
Thank you, John.
I wish you well.
Thank you. Chris, Clement.
You can unmute.
Am I unmuted? Can you hear me? Kimo,
We
can you
hear
hear me? Okay, good.
Yeah.
Chris Clement, Norwich. John kind of stole my thunder because I was going to say the same thing. Historically, in the last 4 years, you guys have a total of, I believe, almost 80 executive sessions. That is unheard of. They're supposed to be used sparingly. The second thing that we have noticed in your pattern, when I talked to the Attorney General's office about my OML complaint, and I talked to them and I said, there's a pattern of behavior. And I don't want to reiterate what John has said because he said it very concisely. But what I want to take it one more step is the OML is very clear with executive sessions. There are, I don't know, 10 citations. I don't remember the amount. You guys come up with a subject matter and then use the OML executive citations like an a la carte menu. You just say, well, we've got this problem. What can we use in order to get into executive? That's not how it works. For the very reason that John just stated. I have heard you guys say you're going into executive so many times when you say, I don't really understand what this is. We just need an opportunity to discuss it. That's not what you use executive session for. If you need to understand, like accommodation review, be versed in it before you come to the meeting. Don't say, we want to go talk to a lawyer because we don't know what it is. But you guys have done that repeatedly. And if there is a substantial disadvantage, sure, you can go in and do it. But that's how we have seen this pattern of behavior of how you guys pick and choose, well, attorney-client privilege, or we're going to reprimand an elected official, which you can't do anyway. So again, I'm going to say that out of the 80, I have a list of every executive session you guys have gone into. Your reasons for going in are oftentimes erroneous, and we obviously don't know what you say, but coming out has also been an issue. So it is a pattern of behavior. I am offended that Mary actually would say that she would consider Chris bullying. He knew that you guys, both of us have been watching you guys violate the open meeting law so many times. In order for him to substantiate his claim, he needed to do a PRR. And that is not bullying behavior by any stretch of the imagination. He needed to get his documentation in order to do the right thing. So I would say he was by far more together with what he needed to do than you guys have going into your executives. And I don't want to get into the weeds on what you guys did to Cheryl and Pam, but that was one of the perfect examples where you guys just had a beef about it and you a la carte menu. How can we go into executive because we don't want to talk about it? So Matt said it, and I hope you guys now know or have a much better idea, not just how to go into executive and how to come out. You got to have a good reason for going in the first place. You can discuss a lot of this stuff in public. They're not used to just go in there to have a, oh, I don't understand what's going on kind of session. They're very specific things. So again, I would appreciate if any one of the board members, any select board members would not accuse a member of the public as bullying because they asked for a PR, public records request. That's a pretty standard thing that people do when they feel that the town, any select board member or any elected official has violated a law of any kind.
Okay. Again, I think we're getting a little bit away from, but thank you for those sentiments.
I didn't mean to get away from it, but this is what this is about.
Oh, no, I know it, yes.
I'd just like to clarify or respond to Chris's remarks that I'm not suggesting that Mr. Katucki has exhibited bullying behavior for filing a public records request or for asking for any documentation that he might need in order to increase his understanding. What I have felt is, in what I call asymmetric, is just in the court actions themselves, it seems to me, and maybe it's just a tactical lawyer action, that there There have been other elements thrown in to make it more expensive for the town. That's all. I don't consider I don't consider Chris Katucki to be a bully, but I do think that, he's a very clever lawyer, and he's going to use both, he's going to use tactical means, I think, as well as the actual interpretations of the law that would prove his idea of the case. That's all.
Brandon?
So I think in the fallout from the case in 2023, when I think Justice Samuel Hall ruled in May and the town eventually settled in December, towards the end of that period, 5, 6, 7 months, Mr. Katucki was quoted in the Valley News or Vermont Digger or something, and it was really quite revealing, quote, that I think revealed his intentions. I've been looking for it and I cannot find it. If anyone can find it for me, please do so. But basically his simple one-line quote was, "Open government and adherence to open meeting law is the fundamental bedrock of our democracy." This to me tells me something about his motivations.
Matt?
Okay, I have a couple of things that I wanted to respond to that were said, but I also want to stay on topic. And I want to make sure that we're following the topic that we've set for this.
Thank you.
I'm not completely understanding exactly the topic that we're focused on. So I don't want to contribute in ways that stretch this longer than needed or are just sort of responses to other comments that may not be on topic as well. So I'd like to know how we want to move forward here. And I think we're all in agreement that we'd like to come to some resolution and move forward. So might toss this back to you and ask what the next step is, because I think a lot of people have been able to give a lot of thoughts on on this broad topic.
Which is all great. And I think I'd make my own little comment. We have to remember, this is really hard.
Yeah.
Right? We have 5 people who grew up at different times, well, some of us in the same places, knowing different people with different habits and different qualifications. We are not a team in the sense that a soccer or baseball, we don't get to work out together and practice our moves. We only get to talk in front of everybody. Right? It's not easy, right? And so I ask that you remember that. And funny, difficult, complicated stuff comes up. And the first response that most people have, I think, in the world is to go off in a corner and talk about it, to understand it before you talk to anyone, before you do it publicly. We have to do that publicly. So, we do things in a slightly funky way, and I apologize that we did that. And yeah, sometimes we'd really like to go talk about this privately so that we can make sense of it, even if we're not going to do anything. So we've done that, but it's not because we're nefarious or trying to be mean-spirited or stealing money or engaging in some kind of crime. We're just 5 people trying to figure out how to do the best by the town. And we're going to do better. Yes.
Mr. Chair, you are 100% correct. We cannot practice. We cannot horse trade in private. We cannot rehearse. The system is contrived to put our debate in front of the public with all its tortuous pretzelizations and negotiations. This is what the public demands to see.
Yeah.
And this is what we are stuck with by statute and state law. And I'm okay with it.
What are we going to do? Like Matt has sort of asked us to get back onto the.
Item 3, what we're meant to be discussing are the proposed responses to Katucki notification of wellmouth violation filed with the town of Norwich on the 6th of April, 2026, and the PRA suit file in Windsor Superior Court on the 4th of May. That's it. We'd like to discuss how to respond and perhaps find a way to resolve these issues that Katucki has with Norwich. Mary.
I have a question about the OML violation. What's left? Because I thought we had cured that.
We have, yes, gone a very long way to curing that. My feeling was that discussing having the ability to discuss the entire set of conditions and cases all at once would help us understand, in particular, the PRA suit. So if we only are allowed to talk about the PRA suit, we can't talk about anything leading up to it, related to it. So
It's just a way to frame the discussion. But so I think we're caught up with the OML violation. I mean, we got a whole policy, I believe that's cured. So you're just saying in terms of framing the discussion, that's why that's in there.
Yep.
So does that mean that we should focus more on this Public Records Act violation?
my own opinion is, PRA
The
suit.
PRA suit, right?
I believe that's what we will do.
Okay.
Yes.
That's exactly what we should do, Mary. Thank you for framing that. The PRA.
Just trying to understand
Yeah.
what we're doing here. Yeah.
And Mr. Chair, if I may, we have to deal with the PRA suit, the 26 CV 02624 case number. We have 5 counts to address. And in the interest of streamlining things, because the clock is ticking on this, we have to reply to the court by July 24th, which is 9 days. So we don't have a lot of time. I know we spent 6 months on this, but the clock is ticking and the finish line is coming up real fast. We have 5 counts to deal with, the first 3 of which are very closely related. The last 2 of which, 4 and 5, were centered around the issue of costs, screenshots, and all the other miscellaneous type happenstances around access to the documents, reimbursing the town for labor costs and things such as that. My suggestion is that we focus, and you're right, Mary, you're absolutely right. The OML notification, the violation, is largely being resolved. We're almost at the end on that one. Mm-hmm. If we put that to a side tonight, and in the same manner, we put to one side the cost issue, which is quite modest, it's $545.40. If we just put that to one side and take it up at another time, I don't think we need to thrash that out tonight. But if we focus our attention on counts 1, 2, and 3, which is really 3 variations, closely related variations of the same thing, the applicability of statutory exemptions to redactions in public communications between departments of the town. Now, Mr. Katucki alleges that we are not a department of the town. Absolutely correct. We are a legislative body put here by the people. So to the extent that statutory redaction exemptions apply to departments of the town, that is a bit of a red herring when it's talking to the select board. Mr. Katucki's 3 counts. Count 1 is improper redactions within select board intra-communications. Count 2 is improper redactions in communications between the town manager and the select board. Count 3, again, very related, communications between the select board and the town clerk. So they're all extremely closely related. All that differs is the quorum of communication, the groups involved, the people communicating. But the same common theme descends upon all counts. I think what we should do tonight is focus on resolving the response to Mr. Katucki's claim regarding those 3 counts. 1, 2, and if you have do you have great, okay, you've got it. So the OML violation, we're almost there. That can wait for another night. I think just to simplify things tonight, so we can get out of here at a reasonable time. But it's very important, and we've got 9 days to do it.
Mary?
I don't think it's enough to just deal with counts 1, 2, and 3. And to me, the costs and the access to the records and how that is done, to me, it's the central part of the case. And it's the part that's most related to however it is that we frame our future policy. So to me, I would not just sit on 1, 2, and 3. You know, I think they're closer to the OML, concerns that we've have had on an ongoing basis. But I think that 4 and 5 are the heart of the case and should not be, we should discuss them tonight. I'm not sure on count 3, has to do with the town clerk, not sure on that one. And count 2, wondering if our communication with the town manager is different than our communications with each other. So there may be some justification in redacting some of advice that may have been given by the town manager. So
I'm going to ask you all to say what document. We don't have a packet today, so the public can't see what you're looking at.
all right,
Without our telling them where to go, or taking this into executive session where we can discuss these.
I think our intention is to try to figure out a way to settle this out of court. And though, because it is, because it is a suit, discussing this in public here, puts us at a disadvantage.
A little bit, yeah.
Because we might be talking about, some give and take. Is it possible to go into executive session and to hash this out and perhaps come out with sort of an agreeable solution for everybody? Because I would agree that we're all taxpayers here, including Mr. Katucki, and we should all aim to have an agreeable solution for everybody.
Well, are there any other public comments? Public discussion? Yes.
Thank you, John Carroll. I guess first to the idea of taking up the fees and all of that, which I understand is a concern. You do have a roadmap about how to address fees already.
in the case of people without a disability, though. Is that the roadmap you're referring to?
I'm referring to the Secretary of State's fee schedule.
Okay.
That is the law for you. It states very clearly in the PRA that if you have not adopted a public records policy, which you haven't for whatever reasons, then you must rely upon the Secretary of State's fee schedule. Period. End of sentence. No choices about the matter. You can't just go and make up your own idea of what somebody should pay in fees. You can't do that. You must do it according to the fee schedule. I don't have it with me. If you haven't looked at it, you're not prepared to talk about fees because it's the rule. And none of this is news. I mean, I did mention this to you about a month ago.
Could I respond?
Yeah, pardon.
I'd like to respond to that. So it's very clear on the rule if a person would like to come in and have copies made. That's very simple.
Yep.
But what's harder is when the person cannot show up to receive the copies. And then also that there's an option for inspection. A person can come in and inspect
Understood.
the records. And so I think the accommodation, it's like, how do you provide inspection for someone for whom it is not possible or convenient to come in,
Those
if
are-
that person chooses to do that. So I don't think it's as simple a matter as you may be suggesting that it is.
Well,
And I have read those. I have read the fee schedule and I have read the procedures, and I don't think it's that simple.
then until you adopt a policy, you are, you have only the Public Records Act to go upon. I can readily concur with you that it would be great if we had a policy. You don't. You don't have, I think, time to develop a policy between now and the 24th of this month and use that as a response. I would just, it's been well over 2 months since this case was filed. You've had extensions, and I think you're left with needing to respond as much as you can. I grant you that the special accommodations are complicated. I have no idea what the law says about that, but I doubt that you can charge special monies because somebody has a disability. But I don't know that. I just kind of doubt it. ADA and things like that get in the way. All I'm suggesting is that, yeah, there are a whole lot of unanswered questions there. But really the central question is the withholding of documents and the redaction of documents. And was that done appropriately? And that's the question you're being asked, that Mr. Katucki asked the court in number 1, 2, and 3. And I would just remind you that 2 of the 3 exemptions that were claimed by the town manager, 2 of them are simply not in the law, the public records accommodation law.
So you're back to the 1, 2, and 3.
Yeah, I'm just
the redactions.
addressing those, and I'm just pointing out that those exemptions are common law exemptions. They do not exist in the statute. The statute never mentions them, that is executive privilege and legislative privilege, deliberative privilege. The statute does mention the interdepartmental privilege that has also, there are 3. And only of the 3, only 1 is actually mentioned in the statute. It's not to say that they don't exist, but you have to ask yourselves, remember the Supreme Court has made it very clear, you must err on the side of transparency. If in doubt, give them the document. I can see that you would have some doubts about the applicability of deliberative privilege, whatever the heck that is, or executive privilege, whatever that might be. And if you have doubts about those things, the default is release the document.
Okay, thank you.
Thank you very much.
A question I would have, I think it relates to what John is saying, is that, well, what if we just had the authority, because I know we've talked a lot about authority tonight, just to waive the cost of copies? Do we have that authority? That would have simplified the whole thing. Just waive the cost of the staff time and the physical production of copies.
We have
A
that.
particular case, or would that set a policy precedent?
It might set a precedent.
That would be, to me, a lawyer question, just saying of why we might want to ask.
Yeah, we should probably ask that. I have asked that. If we're worried about setting certain precedents, we don't have a policy right now. So I treat this as a one-off personally. This is something that came up, we weren't prepared for it, we don't have a policy.
You're saying you treat it as that, but what is our legal framework? What is our authority?
What's our story?
No, what is our authority? We've been talking about that a lot. You're saying, well, let's just give them I think that makes sense. Let's just do that. But you can get into, a big rat's nest with that too.
So what I would suggest is adopt a policy following whatever we do. From now on, we have a
Right.
policy. Right now, we don't have a policy.
We don't have that now.
So establish a policy after we have solved this. Admit, we should have had a policy before, we don't. So we can't really follow the policy, we can only follow the statute. But if we write a policy after we're done with this, or part of being done with this, then we follow the policy from now forward.
Here's another thing about it. So the Secretary of State does have the framework, right? You can ask for copies and you have to, pay for them. And then it has the policy for inspection. But if the person can't show up to inspect, I don't think there's clear guidance on that from the Secretary of State. So that's why we are in kind of this odd limbo.
That's right. That's right.
But it's,
So we need to negotiate a way to provide documents in a manner that is not described in the statute.
okay, so then are you saying that perhaps it is appropriate that this is being litigated? Because, I think what we're asking is for a judge to give the best answer to this question, right?
I don't.
Are we in an appropriate framework to resolve this? Because Secretary of State's, their procedures are not able to have us resolve this legally.
Well, if it's not in statute, it's very clear, we are the authority. And if we write a policy, it
We
will,
haven't written in a policy, we don't have a policy, so we can't, that's not on the table tonight. We're talking about what we need to do in this case. Or there's a difference of opinion about inspection. Mr.
Yeah.
Katucki has, opted for inspection, but what does that mean for a person that cannot, it's not possible to physically show up and inspect the records. That's what it usually means. A person walks in and looks at the records right in the office.
But that's what we were trying to resolve early on in the case. What is the equivalent? What's the digital equivalent that would allow him to inspect without copying, knowing that he could take screenshots, for example, or use a camera without our seeing?
Right.
Why would we allow that when we don't allow that to someone who can walk into the building? And that was sort of the basis for some of the, I thought what we were doing was negotiating with him to figure out what level he'd be happy with and we'd be happy with.
Right.
And that turned into a lawsuit without our having discussed it further. Yes, Rob.
So, and looking at the responses back and forth between Brennan, our lawyer, and Mr. Katucki, it became clear to me that Mr. Katucki was dissatisfied with the breadth of our responses. In other words, he was somewhat firm, somebody might say bullying, about making sure that the policy that was established afterwards, the response by the select board, by the town, included his desired level of access in its entirety. In other words, that wasn't really a negotiation. There was no compromise there. It was, no, maybe you can give me the unredacted emails, but I don't want that to be considered the end of this situation. So the need to, I think the benefit to having an executive session with the attorney is to determine what the possible negative ramifications of acquiescing to his requests end up as.
Yep.
And I think that's perhaps fulfilling enough public knowledge of why we're going into executive session, because we may be discussing things that are part of a negotiation, the breadth of which could change depending on what we think the legal response will be.
Yeah. Good. Well said. Yes.
Earlier this evening, I suggested we defer consideration of counts 4 and 5, the financial questions, to another time. But I think,
Again, the public can't see what you're talking about. I would like to defer these questions to an executive session if we have one.
but I,
Because they have no way to understand what you're talking about without a document in front of them.
but it's on the Vermont Judiciary public website.
Okay, well, I think if you state that and tell them where they can find it, then we could probably
Yes.
discuss it. But
So this is I forget the terminology, it's like the case progress, the order of events in the case as it proceeds through the court. This is 26-CV-02624, filed Superior Windsor Court, County on May 4th, 2026. So that's the 26 prefix of this case number, denotes the year.
thank you.
So although I did propose deferring discussion of counts 4 and 5, the financial considerations, albeit modest, Mary clearly thinks this is an important issue, and absolutely I acknowledge that. But I want to commend her for even suggesting the very creative and interesting solution to waive the fees
Yeah, can we just do that?
as a means to move things forward. And
Right.
that even goes further than my suggestion to defer them for another time. And I want to thank you, Mary, for saying that. That's really creative. And
Well, it might be a stupid decision though, too.
also, we are the deliberative body. So as I
Right.
mentioned last time we convened, this is government for the people, not government by law firm. So we are the people's representatives. And creative suggestions like the one you just made is the cornerstone of us getting to consensus. So thank you for that. I really appreciate that.
Well, hope it helps.
And to Rob's point, I do contest the phrase acquiescence to Mr. Katucki. He is a citizen, resident, taxpayer of this town. He has as much right to interrogate the public records of this town as what any of us do, or any of you do. Acquiescence and appeasement are not terms to be used here. We are obligated to be servants of the public. They have every right to see whatever we deliberate on. Acquiescence and appeasement are the wrong terms to be thinking of here.
If the person requesting those public records is asking for consideration outside the statute, outside the expressly allowed access, I would consider that to be something over and above what is spelled out is allowable, is appropriate. To go beyond what's spelled out as being appropriate, I would call acquiescence. If he can have access, if a member of the public has access to view read-only the documents, that's what the public records law seems to be providing for people. The ability to copy, the ability to disseminate exact copies to others is the area that they pull up as being susceptible to additional fees.
All right.
And
Mr. Chair.
We have a hand up. Chris?
I'm sorry. Oops, hang on. I've lost you. I was reading DSA. Hang on. Multiple screens. I was really actually going over the access to public records 318 DF, or no, F18. And it's very clear. Bob just made it really confusing. I'm not quite sure what you guys are going at, but if you guys look at VSA 318F, it very, very clearly describes, and the town had an option how they wanted to deal with this. So I'm not sure how it is that you're now facing litigation and you still don't know if you were going to charge them or not. That's what you went into executive session for. So under F, it says, I'm going to read it really quickly. If a person making the request has a disability that requires accommodation to gain equal access to the public record sought, the person shall notify the public agency of the type of accommodation requested. I believe that's why you guys thought you were going to executive, because he did have a request. The public agency shall give primary consideration to the accommodation choice expressed by the requester, but may propose an alternative accommodation so long as it achieves equal access. The public agency shall provide accommodation to the person making the request unless the agency can demonstrate that accommodation would result in fundamental alteration in the nature of its services, programs, activities, or an undue financial and administrative burden. I think I think you guys are a little late on the take on that. The record's there. You guys have the authority to make the accommodation. You went into executive and you didn't come out with anything. And now you are sitting in this, still not knowing what to do.
I think that's worth clarifying.
Yes, I think that is worth clarifying. Would you like to?
Sure. A long time ago, he requested an accommodation. We went into executive session and we discussed all the various accommodations that we could make. And we came up with what we thought was, short of giving him everything digitally for free to disseminate an exact copy to everyone. Short of that, we kind of offered the next best accommodation that we felt was more than reasonable. It's still a discussion, but we certainly stepped up and tried to give as much of an accommodation as possible that we thought was very reasonable.
Well, you have the authority. You have the authority to do it. I don't think it's a one-off, and I think Kimo's right. I've been trying to urge you guys to get a PRA policy going for a while, and the sooner you step up, I don't see that you're going to have 5 new handicapped people coming in asking for it. So I'd say get over this one and move on. But to dicker over how much money you're going to save on an accommodation review is more insulting. Just make it up.
Yeah. Okay, thank you. Pam Smith.
Thank you, Pam Smith, Norwich resident. To Chris's point, if you made that decision in an executive session, you did not come out of that executive session and say, we've had a request from Mr. Katucki for an accommodation, and we have come up with an offer that we would like to make him, and we have authorized the town manager to make that offer on our behalf. That did not happen. That's why you're in this mess.
Yeah.
And I'm with Chris, I am embarrassed that you have gone through all of this machination over someone who has ALS. How many people in this town have ALS that you're going to have to worry about whether you have to make some special accommodation for them for a public records request, and one that this board created the situation in the first place that he even wanted to get the records.
And you violated the open meeting law again.
If I may, I don't disagree. I appreciate your comments, and outrage and criticism are welcome, but it's not really what we're here for tonight. So I'd encourage you to write a memo if you're so inclined, and maybe let us move on to what we're here for. Deeply appreciate what you're saying. I hope that didn't offend anybody.
Kimo, it didn't offend me. I just want to know that Mary brought this up. So.
Yeah, okay. Yeah. Thanks.
I'm not offended either.
Okay, thank you. Would anyone like to make a motion?
All right, I'll make this motion, although I have a question about part 2 of the motion. But the first part, I think I can make. Let's see. I move that the select board find that premature public knowledge regarding communications between the select board and the town attorneys for the purposes of receiving professional legal services and discussing the open meeting law violation filed with the town of Norwich April 6, 2026, and pending litigation brought May 4th, 2026 by Mr. Katucki, 26-CV-02624, filed May 4th, 2026 against the town, would clearly put the town at a substantial disadvantage by disclosing privileged attorney-client communications and disclosing litigation and negotiation strategy to the opposing party, which would make the litigation and any negotiation of any favorable settlement protecting the town's interests substantially more difficult.
Is there a second?
Second.
All right, let's, any further discussion? We have further discussion, apparently.
John Carroll. I'll try to be brief. It's very hard to see how a public discussion among you about the complaints that Mr. Katucki has made, which are basically, he's arguing that the exemptions are not appropriate grounds for withholding and redacting documents. That's number 1, 2, and 3. It's very hard to see how your public discussion of that places the town at a disadvantage. This is not a criminal lawsuit where if you were to talk to your attorney, you're defending or you're complaining. If you were to talk to your attorney so that the other attorney could hear you and understand what your, quote, litigation strategy is, and I hear you folks talk about litigation strategy often. I guess I'm just sort of saying, remember, this was a suit against the town, not you, not any specific person, against the town. It falls to you people to respond to it. You are not personally liable for anything here. There is no claim against any individual in the town. This is not criminal. This is a civil complaint. It's very hard to see how you place yourselves at a substantial disadvantage, quote unquote, by talking to your attorney in public. Now, number 1, and number 2, remember, it is your choice to go private. Your attorney cannot ask or expect or demand that you talk to him in private. The attorney-client privilege of privacy is yours to exercise. So I just want to point out to you and to anybody in town who's listening, if you go into executive session, you are saying to the townspeople, well, we want to talk in private with our attorney. Don't have to, but we want to do it. And we want to do it because we think that something awful will happen if we talk in public. I think you've failed to demonstrate that anything awful will happen if you talk with your attorney in this matter in public. And I would suggest that the motion that you have made fails to justify the finding that you have made. You have not presented evidence that shows that the town will be disadvantaged. You've presented no evidence to that effect, and yet that is the grounds for going into executive session. Thank you.
Thank you, John. Chair. Further to that point, I think in our discussions tonight, I've been enthused by the creativity and the advantage that we enjoy by staying in public session, not scurrying off to executive. Mary's, great idea about considering waiving the costs. We're not taking a vote, but it's a great creative suggestion. And it shows a great thought process that the people of this town elected us to make the choices, not the lawyers, not for $185 or $210 an hour, or a paralegal costing $90 an hour. We've already racked up $13.5 grand this year, since March, dealing with this case. I don't think the townsfolk are happy with their taxpayer dollars being spent on legal machinations around a case that really has nothing to do with us personally. It is the defence of the townsfolk, because the lawsuit is against the people of our town, not us.
But what? Other discussion?
That's understood that we're not being sued, but we are trying to, but a lot of our decisions might set precedent that will affect, how the town is interacted with, and maybe how public records are released, or like, while we're not personally, in danger, we're the 5 representatives to setting policy and procedures for the town. And I think that, it's up to us to try to get as much information in as many ways as possible before making those decisions that will affect the town and its taxpayers.
Devil's advocate, what information would you be expecting to receive that you'd be more comfortable in private than in public?
I think that if we're talking about a lot of I would like to discuss all the counts. And I think that the discussion of give and take of potential strategy for and against us makes it harder if we were to choose to move forward in the legal way. It would put us at a disadvantage. I would prefer to go in, talk to our lawyers, also, Mr. Smith has been trying to negotiate this outside of court, and I'm not sure where he's landed with Mr. Katucki. And I feel like hearing all of that would be important.
But not in public.
I don't know what was said. That's sort of the push me pull you here, is I'm not sure what might come up or what was said. And so sometimes it's hard to know, whether we should have been like you have it out here and all of a sudden things have said and we're like, that puts us at a disadvantage.
Okay, any further discussion? Should we vote? Klassen?
Nay?
Layton?
Yes.
Here?
Yes.
Sweat?
Yes.
I'm a no. Okay, but it passes. Would anyone like to make the second motion?
I have a question about the second motion as written. If the first part of it goes through under what criteria to enter executive session, then it says invite the town attorneys, and after an initial discussion with only the town attorneys, invite the town manager. So why not invite the town manager for the entire session is my question. Why was the motion written that way?
For 2 reasons. One is because I asked if we could do that. We 5 people never get to speak alone, and I thought it might be useful. Also, I thought it might be useful for us to develop a strategy, which we then direct the town manager to help us with.
So you're saying the presence of the town manager as somehow preventing us from making decisions about how to direct him?
I think that it's safe to say that in any group, the more voices you have and the more opinions that are expressed, there's a change in how the discussion goes. We are the
Legislatively elected people.
yeah, we're the deliberative body. And we have a town manager whose advice we value, which is why we're inviting him in. But I felt it would be good for the 5 of us to speak with the lawyers about what our strategy might be, and then afterward invite the town manager to join us to further discuss it and then tell him how we feel the select board would like to proceed. We never get to talk, just the five of us. Well, there's a difference.
We have to be,
And this is not, there's no, I'm not trying to insult anybody. I'm just saying we are the deliberative body. And the five of us should be able to speak with our lawyers and decide what direction we want to go in and not worry about how it's going to be interpreted or so on by, someone else in the room, whoever they are. We ought to be able to do that. That
was your reasoning.
Yeah.
All right, well, I am more inclined to have the town manager there for the entire session, so I would not be inclined to move this in this form. Maybe someone else would.
I'm prepared to propose the motion, Mr. Chair.
All right.
Can you pass me
Yeah.
this? Would love to have printouts going forward. We are number 2 here, right?
Yep, this one.
Yes. I move to enter executive session for the purposes of receiving confidential attorney-client communications made for the purpose of providing professional legal services to the town in relation to discussing the OML violation filed with the town of Norwich, April 6, 2026, and pending civil litigation against the town brought May 4th, 2026 by Mr. Katucki, case reference number 26-CV-02624, filed May 4th, 2026, from town attorneys pursuant to 1 VSA 313A, subsection 1, subsection E and F, and invite the town attorneys into executive session, and after an initial discussion with only the town attorneys, invite the town manager to join the executive session.
Would anyone like to second?
I'll second it.
Any discussion? No discussion? We'll vote. Clausen,
Yay?
Layton,
Yes.
Peer,
Yes.
Sweat,
Yes.
Griggs is a yes.
So we have to have the time on that, right?
Well, you're a little late, but
Thank you. Just
7:04.
quick,
yeah,
at risk of being a bit of a nudge, I just want to,
we just entered
Just entered though.
executive session. I'm sorry.
and
You-
would you like me not to speak or to speak?
Yeah, I don't think you're allowed to.
Okay, fine.
Later.
That's fine.
But I'm sorry. I looked over and your hand was down. I'm sorry. We've entered executive session at
7:04.
7:04 PM. We will go to the Lister's office. You are prepared to host this? Are you signed on?
I'm going to do so now.
Okay. Do you have enough power?
Only conferred upon me by the voters, Mr. Chair.
Yeah, okay, battery power I'm talking about. Okay. And Brian, John, we will join you in a moment. Thank you. Ready? Let's move into the listers. Ready?
Recording stopped.
Thank you.
Recording in
documents,
progress.
unredacted, at no cost, without restrictions, to pursue a settlement of the lawsuit and to defend the lawsuit to the extent necessary relative to the Katucki. What do I call it? The Katucki.
Case.
CRA lawsuit.
Do I have a second?
Second.
Was that Matt? I think so.
That's Greg's. Sweat. Any discussion?
Just a question. Mr. Chair, John Carroll. Not sure I heard you correctly. It seemed like you said you moved to direct the town council, is that correct? Or was it the town manager?
Town council. We are authorizing council to provide the requested documents unredacted. Council,
Town council doesn't have possession of the documents. They're in the possession of the custodian of public records, aren't they?
Good point.
yeah,
I think both people have them. And council has been negotiating back and forth with Mr. Katucki. I
Understand.
get what you're saying, though.
Understand.
There's one custodian.
I just would wonder if they are in the possession of both, you might direct them both. I'm just,
yeah, good.
it's confusing. The custodian of public records is the person responsible for
No.
holding them and delivering them.
Would you like to rescind your second?
Sure.
Okay, I rescind my.
You can amend it. You can amend it. You don't have to
We'll
rescind.
rescind it, we'll make a new motion.
Withdraw and then
Thank you.
again.
So rescinding that, we move to authorize the town manager and council to provide the requested documents unredacted at no cost without restriction to pursue a settlement of the lawsuit and defend the lawsuit to the extent necessary relative to the Katucki lawsuit.
I'll second.
All right. Vote. Clausen,
Aye.
Layton,
Yes.
Gear,
Yes.
Sweat,
Yes.
Griggs. Would anyone like to make a motion to, well, we have a public discussion. Yeah, I already made, but we wanted to have public discussion afterwards. We hope that the provision of the documents that have been requested by, will satisfy him. And we hope that this might bring the end to the legal case against us. I want to say throughout this process, there's been a lot of discussion about who was responsible for what. There's been some blame ascribed. We've taken some criticism. And I just want to point out that I believe that everyone did as they thought they should do and were allowed to do legally. Our town manager in particular, he got a public records request. It was complicated. He, working with council, as the holder of the public records, decided how he might satisfy the situation, given its complications. And I believe did what he has done in the past, what he was legally allowed to do, consulted with Selectboard as was appropriate. I think there may have been some confusion about among the Selectboard, some of us inexperienced, about just what the process would be, whether we were negotiating and continue negotiating, or whether we're taking a position and holding that position. I don't think there's been any back channel, unexpected illegal behavior, and I appreciate that everybody's kept their cool in a pretty heated environment. I think often unnecessarily so. And I appreciate that we've been able to come to some conclusion together on this. It's, you know, it's a complicated matter, and we have to talk it only in public, for the most part. And, yeah, so I just wanted to say that. I know other people may have comments they would like to, thoughts they'd like to share, but what did I forget?
That's good.
Yeah. Anyway, I appreciate you all. I appreciate the town manager and the rest of my select board for getting here. We'll see what happens next. Chris Clement. You're back.
Hi, Chemo. It's great that you guys, sounds like you're heading in the right direction. I just wanted, I know there was some frustration going around and around in circles of everything that was discussed, but I want to make a point that one of Chris's specific cures in number 6, take reasonable steps to avoid similar violations in the future, including disclosing the nature of the executive session in meeting agendas and developing instructions to accompany draft motions to assure Trombley is followed. So that was one of his specific cures. So I'm with Chris on that I think going forward, that given that that's one of his specific cures, that I hope you guys have learned a lot from this. And I think that was his intention, or he wouldn't have put that in there. That's it.
Thanks.
Thank you, Chris.
Take your hand down.
Oh, yeah. Hang on.
Thanks. All right. Anything else? Yes, Mary.
Just if since we have developed policy around avoidance of quorum communications, if that should go on our website or be included in our policies. So it's clear for that piece.
Yes.
Yeah.
Oh, shoot.
So for warning of agenda items, because it was in the minutes of May 13th.
Yeah.
I don't think we did put it on the website,
No,
put it within our policy
Not yet.
document, so.
Get that done.
Question, observation. It sounds like you're talking about the notice of violations.
I'm talking about our cure,
Yes, the cures
which is
connected with
our
the notice
policy.
of violation.
Right.
That's the notice of violations. I'm confused. Did you go into executive session to discuss the notice of violation?
No,
No.
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 You
We're
weren't
just,
You weren't
we're keeping
into-
track of the things that we need to do.
We're just,
Okay.
this is just housekeeping.
So you are yet, as yet unresolved in whatever issues you had about the notice of violations. Is that correct?
Correct.
Right, well, that's what the settlement's about,
I
right?
mean, well, no, wait a minute. The settlement is about
We still
a
have,
lawsuit.
we
We
understand.
all keep getting so confused about
We
this.
still have work to do. We understand that.
So you have yet to address whatever concerns you felt you had been raised by Mr. Katucki's, I think, most recent correspondence in connection with the notice of violations. Am I saying that right?
Yeah, tonight was specifically the 9-day deadline for the lawsuit.
Understood.
The notice of violations and the cures and the admission and everything else is
Another day.
another day.
Okay.
Thank you for that
All right.
clarification.
Just to follow up on what your summation. You just agreed to make available to Mr. Katucki all the documents. Some documents had been withheld and not yet provided, and to unredact all documents. Is that correct?
Requested documents. He's asked for some of them be unredacted and
Right.
not all.
Okay. So I haven't heard you discuss how this all came to pass. Why, here it is today that you say that the resident, citizen of town should have all the documents requested in unredacted form. Seems like a reasonable approach to a citizen of the town. So I haven't heard you ask the question, so how did we ever get in a situation where this citizen's request was essentially resisted very actively? That's one way to put it. Many, many legal hurdles were put in the way as a rationale for or an explanation of documents withheld and documents redacted. So the same town administration, you people and the one person who was your employee, how did you guys go from redacting everything to giving everything? It's unexplained, number one, and number two, what's going to change? Are you going to redact things a whole lot the next time? Or are you going to say, no, we don't do redactions, give them the documents, like you just did with Mr. Katucki? I think there's a very unspoken matter here. That at issue, in fact, was the town manager's decisions to redact and withhold documents. And it was the town manager who chose to do that. As far as I understand it, you never gave him instructions to withhold and redact documents. Tell me if I'm wrong. So without instructions, the town manager chose to do that. And in the end, you have had to pick up the pieces of what the town manager chose to do. It seems to me that that raises a question about the town manager's judgment and performance in this matter. Do you want him to do this again the next time? Do you want him to redact everything? If not, what directions are you going to give to him? Number one, don't do that again. And number two, what are the consequences of having done something which you ultimately said that was completely the wrong thing to do?
Yeah.
I'll stand back.
Yeah, go ahead.
So I appreciate where you're coming from, and I understand your questions. The town manager has the authority to respond to public records requests without coming to the select board. He is the person who is empowered to respond to public records requests. I believe the standard in Norwich has been full redaction. Well, that's my understanding. We have done full redaction before. Maybe I need to double check that. The legal counsel recommends it. It's their standard procedure. So I think had the select board been aware of what's happening, they might not have chosen that. But I don't think it's fair to represent that it was somehow underhanded or.
Don't use the term underhanded.
Well, you're being critical of someone who was doing their job in a way that was in accordance with what had been done before. And he completely has the right to do that. Now, I don't think we were aware that was happening. Maybe if we'd been aware, we would have expected it. And I think in the future, probably the way, the town manager works with every select board is going to change over time. Some select boards don't want to know stuff. Some select boards want to know everything. We have to work it out together. And statute is not very clear on just exactly where the lines are drawn. A few months ago, I brought up a agenda item about the fence, like which side of the fence. We had a public records request that's clearly in the town manager's office. When it became a complaint or whatever it was, went it beyond just the records request, I think that technically might have belonged with the select board, but then it became a lawsuit, and that the way the job description and the way statute is written, that became his responsibility again. So which side of the fence responsibility is, chewing its cud is not always clear. So I think it's something we can work on in the future. But I don't think it's fair to be critical, overly critical about the behavior.
Not overly.
Yeah, well, okay, but it's a fair observation. Yeah.
I think Chris Clement might agree with this. It might have been in April where she stuck a VLCT template for Public Records Act policy in front of us and said, why don't you get going on it? But I think that's also, just to answer a little bit of John's inquiry, absent the policy, I think the town manager is doing the most stringent job of whatever the statute and council will allow, just as sort of like, okay, this is like putting on the brakes. But if our policy said otherwise, then the town manager would be working in that framework. So it's just to,
Yeah.
I think we probably all could agree that it would be a good thing to get that policy into place.
Yeah. Agreed. Chris, you have your hand up again. Oh, you're muted. Still muted.
Mute, not mute. Mute, not mute. Okay, so I just want to make sure I understand. I want to go back a couple statements ago. Mary was, I believe, talking about writing a policy about quorums or something. Was that, am I missing that, or?
No, it was just housekeeping, that we, in the draft minutes of May 13th, we
Okay,
had created a policy that was not put on the website yet, so it's just more housekeeping. Probably
Okay, can I-
inappropriate to bring it up.
can I just bring attention to the handbook? I don't know if you guys actually approved the handbook or not, but on page 7, starting at page 6, I believe Marcia, as the author of this, has 4 paragraphs dedicated to meetings and quorums, and she quoted statute, she quoted VLCT. It is so clearly spelled out. It actually surprises me that this actually happened, because Marcia, of all people, said it. So a blurb on quorums, the law applies, blah, blah, blah. She quoted it from VLCT. So you guys have plenty of information, I believe, from the handbook or references to other authorities, statutory authority, if you guys want to revisit the definition of quorum. It's in your handbook.
Okay.
Thank you, Chris. Thanks.
Yes.
Hi, Cheryl Lindbergh, Norwich resident. I recall in this process, there was some frustration that Mr. Katucki requested something, and then when he got denied, he had to appeal back to the same person that had denied him. Is that, so is that something the select board will be working on? In other words, if there's, do you follow what I'm saying?
Yes.
Yeah, it'd be a great
Yeah,
thing
we
to
do.
talk about when we establish policy.
When you do the policy,
Sure,
yeah, so that there's not that back around to the same person. Okay,
Yeah.
thank you.
Any other public comments? Maybe if we're having open comments about Yeah,
this.
open comment.
So I held a couple of clarifying comments to statements that were made that I think were worth, that might have been, that were stated and might not be the truth. I'd like to point out that the reference that has been made a lot about the large number of executive sessions that happened kind of during the time a while ago, during the past 5 years, and I'm not sure the time frame, but there were a lot of executive sessions because there was maybe a year and a half of union negotiations, and so those were normal uses of executive session, but they happened a lot because this union negotiation took for a really long time. And then if you're a student of the select board history, you'll know that there was one town manager, and the select board had a lot of issues with it and met in executive session to figure out whether it was a good match. And that was also, those were perfectly acceptable, frequent executive session meetings for personnel issues, the town manager. And then there was another town manager that the same thing happened where it wasn't a good fit. And there were a lot of executive sessions. So I feel like trotting out a number that is extremely large and using an example of and suggesting that it's an abuse of executive session without putting into context the reasoning, especially if you know the history of the select board, which some people do, it's not fair to use that number. We all have valid points, but when you try to make a point and you're using a statistic and you kind of know that it's a little bit skewed, that's not fair. I'd also like to point out that the executive session that we had to talk about a personnel issue that was raised to us by the town manager in a letter that he wrote to us. When we had his annual evaluation, one of the things that came up in that evaluation was that the select board was asking if there was any sort of issues that were going on in town hall that impacted the way our town employees, were feeling, that we wanted the town manager to let us know. We're trying to be good bosses, essentially. And so his letter to us, that was the kind of the seed to one of these executive sessions, was based on that request. And I think that it's unfair of a boss to request something of someone, have them actually do it and raise a red flag, legitimate or not. We were soliciting input where if he thought something was going that was hard. And then we chose to have this executive session to discuss, someone called it an investigation, so I'll use that word, to investigate the issues in private. So we didn't, out of respect to all the people that were involved in it. And so I believe that we were trying to de-escalate a situation, or at least investigate a situation that dealt with sort of the harmony in town hall, and the harmony in town hall is a very complicated issue, and we were trying to do it in an acceptable way because it's a personnel issue in executive session, and then we came out of it and we decided not to go forward with it, but I think that we were able to hear concerns. We didn't feel like we needed to follow up with more people and kind of grill them about what happened because we had taken it as far as we felt appropriate. And I think that the lens at which this executive session is being seen is actually kind of the opposite of what we were trying to do and what we did. And unfortunately, this OML PRA stuff did the opposite of what we were intending. Like, we were trying to handle something appropriately, let it de-escalate, acknowledge things that happen, and then move on. And this did the opposite of moving on. And that's unfortunate because because there we are. I apologize if this seems rambling. I'm still dealing with an extreme jet lag, so I'm trying to string my sentences together.
Doing okay.
You're doing great.
But I'm a little bit frustrated because as select board, one of our jobs is just to, or it might not be a formal job, but at least to try to maintain harmony within the town. And we have elected officials and we have town employees, and then we have our only employee, the town manager. And I think that not enough grace is given to the people who are trying to work hard to maintain harmony. And different people at different times like contribute to that, and different people at different times also exacerbate it. But in this situation, I think we were actually trying to do well, and we were hampered by the fact that we couldn't fully disclose everything that was going on, but it's not as bad as it looked, maybe.
Thank you, Mayor.
I am not an employee of the town, Matt.
I know that. I said elected officials too.
Okay,
Actually-
no offense.
And I wasn't specifically.
Okay, please come.
Cheryl Lindbergh.
No offense was intended to anyone.
No, I'm listening carefully to what he's saying, and I understand. But there was no justification to go into executive session based on the allowable reasons to do that. So what would have been good is to have conversations amongst elected officials to de-escalate and get information. That's why I have a chair of a board, so that person can take some time to talk to somebody else and not buy into a memo. And the memo created the need for the executive session. So I'm just trying to say that there was no basis to go into executive. You don't have that luxury. If there's an issue with another elected official, you need to talk with us. Well, I don't know, it could be cemetery commissioners, could be trustees, public funds. The conversations need to happen.
What I'd like to do is, we have a sort of a regular agenda item now, communications.
Yeah.
I think communications, this might be an appropriate agenda item one day to discuss, but I don't think it belongs.
I'm responding to a comment that I am unclear on that frustrates me because there was no basis. And that was, you can't have the luxury of wanting to chat in an executive session when you don't have the reasons and the basis to do it.
Yeah.
And that's what created this. The memo created it. And you got lured in and you went in
Okay.
inappropriately.
Yeah, but thanks for the comments. Thank you for your statement. Anything else? No? Would anyone like to move to adjourn?
So moved.
Second? Gear, any discussion? Seeing none, class of